Hi, welcome to Estate Planning Using LLCs for Professionals. My name is Barry Haimo and I will be your host. In this video series, we're going to cover a lot of really cool things, mostly about LLCs. We're going to talk about tax law implications. We're going to talk about strategies and pitfalls, structuring agreements, succession, estate tax planning, operating agreements, and problems that people encounter in those agreements. I'm going to tell you why I'm excited about them in a subsequent video, and I'm going to tie it all together in the last video. So I hope you find it to be meaningful and helpful to you, your clients, and those that you are advising. Again, Barry Haimo, thank you for tuning in, and stay tuned for more. Hi, welcome back to Estate Planning Using LLCs for Professionals. My name is Barry Haimo, and I'll be your host. Before we get into some of the substance, I wanted to tell you a little bit about me. So I've been an attorney since 2008, which was a wonderful time to be coming out of law school in our economy. I went to get an LLM in tax. I took every class possible in my law school and tax program relating to business. I love business. I knew I wanted to be in business. And so I coupled my computer science background, law and tax background with my passion for business. And we focus our practice on estate planning and business planning. It's a big universe, and it deals with, on one hand, we have our estate planning, which is like wills and trusts, probate trust administration. And on the other hand, we have business planning, which is really formation through succession and exit. The beauty of it all is that the marriage of those two things is when you have clients that have a lot of assets in the form of companies, real estate, active and passive business interests. And so you have to kind of juggle both of those worlds, especially as it relates to succession and estate tax planning. I've founded several businesses. I've sold businesses. I am general counsel on a couple businesses. I'm an investment advisor. I am investor. I've had a lot of different hats, and I really like business. I like LLCs, and I'm going to teach you a little bit about them as a lawyer, but also a little bit more insightful as well. I think you'll find it helpful. I love talking about this stuff. I like reading the statute. I give lectures frequently. I'm a guest on podcasts and webinars frequently, and overall, I just enjoy this material, and I love talking about it. So I hope you find it helpful to add value to you, your clients, and anybody else you're advising. And so jump right in and enjoy these videos. Thank you for tuning in, and stay tuned for more. Today we're getting into estate planning using LLCs. We're starting off with the history and evolution of LLCs. To keep it short and simple, LLCs are relatively new creatures. Compared to corporations, they've been around for hundreds of years. LLCs have only been around since like the late 70s, starting first in Wyoming. That being said, there is an asymmetric amount of LLCs nowadays. If you look up the numbers, it is clearly the entity selection of choice among the different options. So what are the options? We have sole proprietorship, which is not filing anything at all. We have general partnerships, which is also not filing anything at all. Incorporation of a company, a corporation. We have limited partnerships and various types of limited partnerships and limited liability companies, or LLCs. I have videos on each of these, so I'm not going to get too deep in it here. We're trying to keep it to really focus on estate planning using LLCs for professionals. The three main things that people look at when they are choosing LLCs or other types of entities is limited liability, taxation, management. There's a lot of other considerations, though, that go into helping you decide which one is the right fit. Other things that go into it are ownership, intent and goals, flexibility, are we raising capital, what kind of business it is, and long-term vision. So I don't want to get too deep into all the different kinds of entities. I want to keep it at a high level if I can. So we'll go through one by one, very briefly. Again, I have some videos on our YouTube channel that go more in depth into each of these. So starting with general partnerships, again, you shouldn't really use those. All the partners are equally liable for the debts of the partnership. They file 1065s with the IRS. They're managed by the general partners as a group. This is important for later. So everybody kind of has agency in a general partnership unless the partnership agreement dictates to the contrary. Corporations have limited liability of the partners, the shareholders. They can be taxed in two ways, as a C Corp or an S Corp. They're managed by a board of directors who appoint officers to carry out the actions of the business. If you're not happy with the business performance, then the board will then replace management. So boards are elected, officers are appointed. These go back a long time. S corporations are C corporations in the state in which you form them, who elect to be treated as an S corporation under the Internal Revenue Code. There's a lot of limitations, though, on whether or not you qualify to be an S corp. Okay, so there's a limit on the number of shareholders, the type of shareholders, i.e. they have to be U.S. citizen humans as opposed to a business. You can have businesses as owners of an S corp, but they must be 100% owners, and you have to file a Q sub if it's already an S to make it into a parent sub legitimate structure. So S corporations are really tax designations of a C corp for legal purposes. So therefore, they have the same governance, the same legal. Board of directors are elected, officers are appointed. These date back to the 50s, but have become more prolific since the 80s. Probably since that massive overhaul of the Internal Revenue Code in the 80s, I believe in 1986. Limited partnerships are very prevalent in law firms and other professional entities. There's different kinds with lots of L's. There's limited partnership, limited liability partnership, limited liability, limited partnership, and so forth. They're not worth getting into. They're all kind of the same. There's a general partner who runs it, and there's a limited partner or numerous limited partners who have passive interests. The general partner is usually responsible for all debt, which is why they're generally a company or an LLC themselves. Getting into LLCs. So today's all about LLCs and estate planning. So why LLCs over other entities? Okay. And that's because of a few reasons, one of which is flexibility. So starting with the characteristics of an LLC, that flexibility is manifested by way of members and management. In a company, a corporation, the shareholders are called shareholders, the partners are called shareholders. In an LLC, the partners are called members. Members own membership interests. Sometimes it's a percentage. Sometimes it's units. There's no wrong way to do it. It just depends on the context of how you're structuring your deal. In an LLC, you have management which could mirror the corporate centralized management of a board that is elected and then appoints officers to carry out the business, or it could be mirroring the partnership where you have a bunch of people running around with agency rights to bind the company. In an LLC, it's called manager managed, it's a tongue twister, manager managed versus member managed. Manager managed versus member managed. It is truly a tongue twister. Generally speaking, I would advocate that you do manager managed for a few reasons, and I think we'll get into that a little bit more in detail later. So the point here is that a management can be flexible in mirroring or modeling after different other kinds of entities that work, like corporations and general partnerships. For taxation, continuing on the flexibility theme, for taxation, LLCs can be taxed in one of four ways. And that is C Corp, S Corp, disregarded, or partnership. So C Corp, S Corp, disregarded, or partnership. It's easy to remember. If you're a one-person band, one-man band, one-woman band, you're disregarded by default. If you're multiple members, multiple owners, you're partnership by default. But you can elect otherwise. Those other two ways, C Corp or S Corp. In terms of limited liability, we're going to talk about how that works a little bit more later. Today, we're just talking about the different kinds of entities and how LLCs compare to those entities. Everybody has, all these entities have limited liability with respect to the business operations. The shareholders are separate from the operations. There's like this little intermediary entity that protects and shields the partners or members from liabilities of the business. But that does not protect you from personal liability unrelated to the business. So we got to talk about that. In terms of governing documents, I think it's very interesting because people always, a lot of clients, they don't love that agreements are very long. They think they can go online, they can download a freebie. They think they can go on ChatGPT or whatever this week's AI leader is and produce an operating agreement. I would say, unfortunately, that's not the case. I review a lot of these and they're not good. If I use AI to make an agreement, it is different than a non-lawyer who doesn't do this kind of work, even a lawyer who doesn't do this kind of work, using AI to make this kind of agreement. So I would encourage you not to do that. That being said, they're very long when you get into them. And I thought that this was an interesting fact. I took the statutes for Florida, Wyoming, and Nevada, and I plugged them and I copy-pasted them into Microsoft Word. And I wanted to tell you how long those documents were. The default rules in each state. The default rules in each state, unedited, just copy-paste. In Wyoming, it's 76 pages. In Florida, it's 120 pages. In Nevada, it's 90 pages. So when you're talking about my documents, that might be between 30 to 50 to 75 to 80, 90, I don't know. It depends on what the situation is and the complexity. It's the same in the statute if you don't have an agreement. The difference is that the statute is usually very unforgiving and has a lot of holes. It's better than nothing, but I'm telling you, I've seen litigation over a lot of missteps, from Mickey Mouse agreements, free online agreements, AI agreements, and using the statute where it fills in. So operating agreements, which is what the governing document is in a LLC, they're long. There's intended to plug a lot of holes in the boat. You're probably never going to plug all the holes, but it's a lot better to have an attorney do it than not. I'm going to close this video and go into the next video, which is going to talk about putting it all together, the nuts and bolts of the LLC, and more importantly, my top reasons that I love them. So stay tuned for the next video. Hey, welcome back to Estate Planning with LLCs. My name is Barry Haimo and I'm your host. Today, we're getting into the top reasons that I love LLCs. So if I were to say why I love LLCs, I would say flexibility, 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 flexibility. I call it the ultimate hybrid. The ultimate hybrid. As I mentioned in the last video, you can mirror the centralized management of a corporation. You can model management after a general partnership if you want. You can enjoy 4 different kinds of taxation: C Corp, S Corp, disregarded, or partnership. There's an unlimited number of shareholders, more akin to a corporation, whereas S Corps are very limited in both number and type. You can foster creativity in deal making. I'm very creative. Our firm is very creative when we problem solve. And that is usually severely hampered in the form of a C Corp and especially an S Corp. You have more ability to modify unmodifiable terms that are not available in a corporation. So you have flexibility to really make your operating agreements reflect the economic and other realities of your business and your investments. And lastly, they're really helpful tools in estate planning, estate tax, and succession planning. So I like them predominantly because of the flexibility. So key provisions of an operating agreement is next. What is an operating agreement? What goes into it? I talked about last time in the last video about using AI and being very careful with using AI. It is very different when I use AI as a tool, where I've been doing this a long time. I've probably looked at 1,000 operating agreements versus another person who doesn't understand the issues. They don't understand the holes and how it all fits together. So be careful when you go online and you use these tools, okay? They are helpful, but they're dangerous, and you should be aware of that. So what goes into an operating agreement? I would say taxation, management, meetings, ownership, transfers, buy-sell, conflict resolution, allocations of profits and losses, and distributions. I already covered taxation. You can do it in one of 4 ways. That's a big deal. I think I talked about management already. Member managed, like a partnership, or manager managed, like a corporation. The operating agreement will flesh out roles and responsibilities, rights, obligations. If you're doing a deal, you need to make sure it's very clear, because it can be blowing up in your face really bad. Or I shouldn't say your face, your client's faces. You can have different kinds of voting, different classes of on the capital table, the cap stack. Whereas a C Corp can have different classes, an S Corp cannot. It's voting or non-voting. An LLC can have a lot of different kinds of classes, like a corporation, but a lot more to it. You can have, as we're going to get into in a little bit about allocating profits and losses, distributions, you can really get creative in how these classes have economic rights that are different from each other. It's only available in an LLC. I think that a really important thing I've seen is meetings. Meetings are the least fun thing to talk about, but I've litigated the issue of how meetings can make or break people's lives because of litigation over how they're done. So really pay attention to things like who's qualified to call a meeting. How do you call a meeting? When are the meetings to be done? How are they conducted? What notice requirements are needed? What quorum is needed? Quorum is the amount of people that have voting people that have to be present at a meeting with notice to carry out an action. Can you do it in person? Can you do it on the phone? Can you do it by video? Or can you do it what's called an action in lieu of a meeting, which is when you have all the people, typically all the people that are necessary, signing off in a writing. I've seen this blow up. I'm telling you, don't Mickey Mouse it. Don't think you can just have AI record it. Don't think that it doesn't matter. Because it does matter. The law does say it matters. So next, ownership. A good operating agreement will delineate ownership. It will identify and identity and contact of members, which is the owners. It will identify the rights of each class of members, whether it's Class A, Class B, Class C, voting, non-voting, economic rights only, which we'll talk about a little bit later, called a profits interest. It will identify obligations, employment obligations, capital obligations like capital calls, and then also limitation on rights. Withdrawals of capital are usually forbidden. Once you put the money in, you're not getting it out unless management decides. All this should be in there. It's really important. It will further document transfers. Transfers are so big. I can't stress it enough. Transfers are so big, and then in conjunction with meetings, transfers, there's a lot of moving parts here to how the statute would deal with it, but you want to establish your own rules. When it comes to transfers, you want to identify and define restrictions. Are they allowed? Are they not allowed? Or are there exceptions to not being allowed? Who is required to approve them? What happens if there's an improper transfer? Typically, you'll see something called a ROFR, right of first refusal. A right of first refusal is a really interesting tool. It basically means that it's usually used in conjunction with a limited transfer rights. You can have a member they can't sell their interest to a third party until they give the current members the same deal, an offer for the same deal. And that's intended to make it really hard. A good ROFR provision will be really hard to do. You'll see it say something like, if a bona fide offer is presented to a member, they have to then, in a certain amount of time, give the same offer to the existing partners in a certain way. Those partners have a certain amount of time to decide. Then the company has a certain amount of time to decide. If they decide they buy it, then that third party is out. Keep it in the family, so to speak. If the partners and the company don't timely exercise their rights or reject the offer, then the third party can proceed, but then there's like a lot of timelines that they have to comply with. And the idea there is that you want to make it hard to get rid of those shares to other people, because you don't want your partners to be in business with someone they don't know. That's a really big deal. In terms of transfers, the operating agreement will also identify involuntary transfers, death, disability, bankruptcy, divorce, termination, retirement, etc. As I mentioned in my prior video, I have a lot of videos on this stuff on my YouTube channel. So I go into detail on all this stuff. So I'm trying to hit this stuff at a high level for you so you get the big, broad paintbrush here. So continuing with the operating agreement, buy sells. Very important, super important. What happens if any of those triggers I just mentioned a minute ago, death, disability, bankruptcy, divorce, retirement, what happens if they happen? Without a clear document, you're going to have someone that could just stick around, or their families or their heirs can stick around in your business, or their creditors can be in your business. So you really want to approach this. So triggers, identifying triggers is one. Identifying the value, fair market value, is it an appraisal, shotgun, is it a formula, there's a lot of ways to do it. It depends on the deal. All of them have benefits and disadvantages. There's no golden goose way to value the company in a way that is not super expensive but also is practical. In terms of the mechanics of transactions, if there's a buy-sell, how are they going to work? There's usually a down payment, a certain time at closing, then there's like a financing period. What's the interest? How long is it going to be? Is there security? These are all things that really matter. Is it insurance funded? Life insurance, disability insurance, for example. It has to address those things. You can't have those things existing in parallel. Conflict resolution, I think, is a big one. Some attorneys, I find, in my personal experience, they love arbitration, and some hate arbitration. They love litigation. I'm not going to get into the details there. I do have videos on that on my YouTube channel. But both have their merits and disadvantages. I would recommend always trying to get like some pre-litigation conflict resolution built into the document to try to see if it can be resolved, because nobody wins when you litigate. You want to incentivize resolution outside of court, in my opinion. The operating agreement will also include, I mentioned earlier, allocation of P&L, profits and losses. Typically, profits and losses follow basis. That means the capital partners, the people who put in money or property, typically get allocated the profits and losses first until they're restored. The capital accounts are restored. I'm thinking in my head, like, I remember in school how hard partnership tax was. It was the hardest class I've ever taken in both law school, tax program, and in my computer science degree in the business school at Florida. Partnership tax is super hard. So suffice it to say, you can reallocate profits and losses. Typically, it follows basis, and investors usually are going to get those tax attributes first. You can, however, reallocate that any way you want. There's something called a special allocation. The idea here, as I said, you can't do it in a corporation. You can't do it in an S corporation. You can't do it really in a disregard entity. You can do it in partnerships, which, as I said, LLCs can be partnerships. So that's kind of the lens through which I'm looking at this. You can be flexible. You can say, to give you an extreme example, you can say that a 1% partner, membership interest partner, can get 99% of the distributions and the profits and losses. If you really wanted to, you could do that. And as long as the documentation matches the economic realities, then it's said to have substantial economic effect. That is the standard. The IRS will honor these types of terms. As long as what you have in the agreement mirrors reality, you can do those types of flexible things. Okay. Lastly, distributions. Distributions of profits, that is. Typically the waterfall, capital gets paid back first, then pro rata by class. If it's raising capital, usually there's series A, B, C, D kind of thing. But otherwise, typically when it happens, how much happens is subject to the discretion of management. That's important. Is it pro rata? Is it non-pro rata? As I said, the timing, manner, frequency is subject to management. I would say one thing to make sure you're aware of is that you want to have tax distributions, minimum tax distributions. What that means is that in a pass-through entity like an LLC or even an S corp, you're going to get a K1 and it's going to say, here's your proportionate share of profits and losses based on the operating agreement, what it says. That does not mean you got the money. So you theoretically could get taxed on money you didn't receive. I wouldn't call that phantom income. I just call that reality. So you could get $100,000 in income attributed to you that passes through to your K1, to your 1040, and you got to pay your $25,000, $35,000 in tax, and you didn't get a dime. So a tax distribution clause would say, make sure you at least pay as a distribution to that partner the amount of tax that partner is likely to pay on that $100,000. So if it's $20,000, they'll get a distribution of $20,000 at least. Again, positives and negatives of including a provision like that, but it's something to think about. Also, limitation on distributions is important. You don't want to make distributions if you are insolvent. There's rules that will get you in trouble if you're a fiduciary and you're doing that. So I think that's good for this video. Why I like LLCs, the flexibility, the ultimate hybrid, some components operating agreements. In the next video, I'm going to get into pitfalls and mistakes that people make in their operating agreements. Stay tuned for that video. Welcome back to Estate Planning Using LLCs. My name is Barry Haimo and I'm your host. Today, we are continuing to talk about the operating agreement, and we're going to talk about pitfalls, mistakes, case studies, and application. Then we're going to get into asset protection in the next video. So, jumping in, pitfalls or mistakes that people make in the LLC operating agreement. This is again a video for professionals, attorneys, and other people who are either drafting or advising clients on them. So I have this divided into two parts. General mistakes and specific mistakes. In terms of general mistakes, I've mentioned it already in a prior video, but do-it-yourself is a terrible solution. There's kind of two ways to do it, right? You have your online Mickey Mouse docs, and now you have your AI generated documents. I'm not a fan of either one of those. In fact, I think the AI ones are more damaging than they are helpful. I'm having a lot of very smart people send me stuff to look at that needs a lot of work. In fact, more work than would be required if I just did it in the first place. Maybe that won't be the case in the future of AI, but I think it's, as I said in my other video, it's different if I do it as a professional who has been doing a lot of this work, and I know what to look for, I know what the issues are, I know how they all relate to each other, and I can pick apart an operating agreement, versus a person who does not have those types of skills and is relying exclusively on what looks good because it's got a lot of magic words and is formatted nicely. So DIY. Don't let your clients do it. One size fits all is a mistake. Not taking into consideration the very specific goals, intent, facts of each situation. That's a problem. A lack of litigation experience to see the other side of how these things can be exploited is important. Specifically, on the other side, we have, I think, mandatory distributions. I think is a mistake, especially when it comes to asset protection planning. Having a provision that says you have to make distributions, I think, is a mistake. You want it to be discretionarily, and there's a lot more you can do with that. Omitting the tax distributions, we talked about that in the last video, that it's important to sometimes consider a mandatory tax distribution so that people who are getting taxed on the income they're not even receiving can at least pay the tax. Inadequately addressing managerial succession, transfers, restrictions, employment, IP, and covenants. I think all of those deserve their own videos, and fortunately I actually have them in our Bite-Sized Bits of Knowledge series on our YouTube channel. So check those out. Those are the specific things that I think people screw up when they're making an operating agreement. So, case study, 1 of 2. We have a case where, and years ago, I was a 3-partner e-commerce business, fairly successful. 1 partner dies. They used a Mickey Mouse online agreement. They ended up litigating for 3 years, well in excess of $500,000 in litigation to attorneys. A core contested issue in that case was whether a transfer was effective, because that transfer carried a vote that would serve as the tiebreaker for the deceased, following the passing of that partner. So we had an issue on the meeting, validity of the meeting, the validity of the transfer, validity of the voting right. The issue really came down to only a few words that were missing in the operating agreement in this particular case. But boy, did it blow up. Big time. And as I say in my litigation videos on my YouTube channel, it's called Bite-Sized Bits of Knowledge. Litigation is much more than financial. It's much more than business. It's emotional. It affects families. I've seen divorce caused by litigation. They were not in litigation, but one was in litigation, one wasn't. And that it caused a divorce, so it's like an amplified effect. So this stuff is real. It really affects people's lives in an important way. You want to do it right. If you're going to do it right. The statute does not do a good job, and the Mickey Mouse agreements do not do much of a better job either. So, case study number 2. E-commerce SaaS business venture, raised capital, had key personnel with vested units. During challenging times, management and key personnel disagreed as to the vision and direction. So a key personnel left. The core issue here was how to address that departure. It was a voluntary termination. There was a buyout feasibility. The valuation was that issue. It was in financial distress. There was not a lot of money. You know, this is a successful case where the agreement provided the mechanism, and all you had to do was enforce the mechanism. Say, here's what we agreed, here's what's going to happen. And unfortunately, you know, that worked out well. There was no litigation, there was no blow up. Okay, moving on to application. Where are LLCs helpful? I would say they're prevalent in a variety of different contexts. Number one, I got 4 on my list. Number one, ongoing businesses or going concerns, like my case studies. Number 2, raising capital. I would say, barring going public, you can really do a more creative job of raising capital with partnerships, with an LLC as a partnership, than you can otherwise. I think some sophisticated investors are still going to be a little bit picky, and they're not going to want the K1s. They might want a C Corp. But if you have to be flexible to make it work, LLCs are the way to go, that are taxed as a partnership. Real estate is number 3. Nested entities, holding company structures, the parent subsidiary structure, management companies. That's where we see those, and we use those in real estate. And 4, family limited partnerships, which historically were limited partnerships. That's why they're called family limited partnerships, where you have the gifting and moving around of interests for estate tax planning purposes. I think we'll talk about that later. It was a good way of shifting wealth. It was really helpful in terms of the estate tax planning, but it also has a really important asset protection planning benefit in many states, including Florida, Wyoming, Nevada, Delaware. So the next video, we're going to talk about asset protection. So stay tuned for more, and thank you for tuning in. Welcome back to another video on estate planning using LLCs for professionals. My name is Barry Haimo, and I am your host. Today we're talking about asset protection. It's a short video, but it's a meaningful one. I have a video on asset protection on our YouTube channel, so feel free to check those out when you have a moment. For today, we're talking about LLCs specifically. I would like to first start with the different kinds of creditors. Everybody forms an entity for this common understanding of what they call limited personal liability. And what that means is that there's a separation between the owners, members, shareholders, partners, it doesn't matter what they're called, and the liabilities of the business. So if a business gets sued, those liabilities, the exposure is limited to the business. It doesn't get up to the partners. That is what I would like to call an inside creditor protection. So an example, you have a hair salon or a nail salon, a salon of any kind, and you do a shitty job and the customer's mad. You cut their hair, they had a photo shoot, they had a contract that was worth $1 million, and now they're not going to get the contract, they're suing you for the $1 million. They can only really sue the business and maybe the worker, which is the business, through vicarious liability. They can't sue the partners. There's no connection there. Now, I'm not saying that's a black and white thing, because there's ways of piercing the corporate veil, but I'm not going to talk about that today. It's very hard in Florida to do that. Let me give you another example. Real estate. You have a rental property. It cash flows nicely. You got a little bit of insurance. But say that the smoke alarm doesn't go off and your tenants, God forbid, pass away. They're going to sue the owner of the company or the property, which is, in this case, the company. If it's you, it's a whole other problem we got to talk about. But if it's a company, then the worst case scenario for the partners is that bankrupts the company. The creditor gets the company. They get everything in the company. they get the insurance, they get, depending on the size of the judgment, they get everything. Those are two examples of inside liability protection. Now, what I think people miss, including professionals, is the distinction between an inside creditor and an outside creditor. An outside creditor is a creditor of the partner. So in my little example, the creditors are coming down from the top. They have nothing to do with the business. Their claims are against the partners, the shareholders, the members. They have a claim for drinking and driving, texting and driving. I don't know, use your imagination. Breach of contract. They get a judgment, they win. They're looking at all your assets to satisfy that judgment. They sit you down at a deposition in aid of execution and they say, thanks for coming. What do you got? You have bank accounts, brokerage accounts? Oh, you have a company. Tell me about that company. What does that do? I mean, they're going to get the information. They have the legal right to get it. And if your company is not structured the right way, they can take that company away from you, even though the company has nothing to do with the claim. The company is, in this context, just another asset on the table. And so when you start thinking about asset protection, you're looking at legitimate ways to make or to remove assets from being on the table to creditors. So, outside creditors are creditors of the owners, partners, members, shareholders. They're judgment creditors. Now, one solution of my 4 solutions is a charging lien protection. Charging lien protection is in some states the exclusive remedy of a judgment creditor of a partner, shareholder, member, like Florida, in some cases. In Delaware, it's always, in Wyoming, it's always. Florida is the exclusive remedy to a multi-member LLC, not a single-member LLC. So what is a charging order? A charging order, I like to explain a charging order as garnishment of distributions of cash and profits. Garnishment of distributions of cash. If you know what a garnishment is, that's where you get an order that says employer only, pay creditor first, and then pay employee second. And there's nuances there. There's protections there, like head of household protections, but I'm not talking about that. In general, you're redirecting where the flow is going. So profits are going to go to the creditor before they go to the partner. That's a big deal. It gives a lot of leverage if you're in control of the company. If you're not in control of the company, it's not ideal because now you're going to get that money redirected. So charging order can be really helpful because it saves you from losing your business. The creditor cannot take the business. They cannot participate in management. They cannot, get rights to certain, books and records and have voting, participation. They just have an economic interest, and that's helpful. That's better. The public policy is to make sure that, your partners are not having creditors. Their partners are not becoming partners with your creditors or your former spouses or your problems that can jeopardize the business. That's not fair to the people. So outside creditors, we've talked about. Charging lien, we've talked about. I should mention one more thing. Every state's different. New York doesn't really have the same protections as Florida. Florida doesn't have the same protections as Wyoming. There's case law that says that Wyoming, protections don't necessarily apply in other states like Florida. I'm not sure that's entirely binding at the moment. So solution 2, structure the operating agreement properly. You want to make sure that you're really tightening how things work in that company, and it will be respected if it's done properly. Solution 3, in Florida specifically, husband and wife ownership is a low-hanging fruit of protection. Husband and wife owns an asset and they do it the right way. A creditor cannot take an asset unless that creditor has a judgment against both spouses. Both spouses. The Trojan horse there is the car, where one person's driving, one person owns it. So having your ownership interest in a company as husband and wife tenants by the entirety in Florida, for example, is really helped. And you can POD that to the trust. which everybody wants the fund to trust. I have a whole video on why I disagree with that, but I'll save that for another day. Last solution is an F as in Foxtrot reorganization, where you take an entity that is otherwise lacking in the outside creditor protection, and you make it outside creditor protected by restructuring it into a parent subsidiary structure. And that's something that we do a lot of, to clean it up. A lot of accountants advise their clients to go into S corps that are corporations that are like S, as opposed to LLCs that are like S. That's a big difference. It's a big difference. So asset protection is a really important concern for a lot of people in estate planning, and it behooves you to learn more about LLCs and how they could be of help and how you can add value to your clients. In the next video, we're going to talk about anonymity planning, which is becoming a very big thing in our practice. Anonymity planning. So stay tuned for that, and thanks for stopping by. Hi, welcome back to Estate Planning Using LLCs for Professionals. Today we're getting into anonymity planning. I'm your host, Barry Haimo. Thanks for tuning in. So what is anonymity planning? Well, as the name suggests, anonymity, anonymous, it means that someone can't find you. It's much more of a priority now in our experience. People are really wanting to reduce or eliminate visibility of their real estate, of their companies. They don't want someone that's looking to sue them to look around and be motivated by what they're seeing. They want the creditors to be demotivated and be like, I don't know if this person has assets. I don't know if this person is worth the cost of exploring if there's enough of exploring litigation. I'm not sure there's enough money. In some states, it's more relevant and that's needed than others. Like, for example, Florida. In Florida, you have to publish a lot of information on Sunbiz if you have a company, whereas in Wyoming, you do not. Nevada, you do not. There's ways around it, but they require some workarounds. I would say our solution is that we deal with a lot of nested entities. We use a lot of other states as well. But this is a big thing. People want this. We have some celebrity clients and they really want it. You know, not just for creditors, but for just, stalkers. We've had some very, non-celebrity clients that just had stalkers that were really starting to get uncomfortable and endangering their family. So they want it to be anonymous. And we do that for real estate, for businesses. It's possible. It just requires a little bit of work. So anonymity planning is becoming a big thing. Pay attention to that. Ask your clients. Is this important to you? And maybe you can add some more value that not a lot of people are doing. So this is anonymity. Thank you for stopping by. Stay tuned for more. The next video is going to be on raising capital and deal structure. Hey, thanks for stopping by to another video on estate planning using LLCs for professionals. My name is Barry Haimo and I am your host. Today we're jumping into raising capital and deal structure for your entrepreneurial clients. We all have them. And we all know that they are running around, their heads cut off, trying to get stuff done. So help them do their job and focus on what they want to be good at by taking care of that legal for them. So what are the material terms of an LLC for your entrepreneurial clients? In my view, you have taxation as a partnership. In many cases where you want flexibility. C Corp if you're raising capital and want to go public, or you have some more institutional investors. In a partnership, you have multi-classes. You have your class A, B, C. You can have voting, super voting. You can have non-voting. You can have economic interests or profits interests. I have a whole video on profits interests. They're really cool. Accountants love them. It's to give you 30 seconds on that, profits interests are a way of giving equity and participation in the income and exit without giving a taxable income on receipt, because that is compensation income on receipt if you are given value you didn't pay for. You didn't buy in. That's tax. So there's ways around that with a profits interest, which is cool. Management, how to structure. Is it manager managed, member managed? We talked about that earlier. Is it a board concept like a board of managers, is that board of managers chosen by any particular classes? These are important things to think about. A lot of times you have investors who say that I'll give you money, but one of my sticking points is I want to have 2 seats on the board. They want control, or they want to at least have a meaningful amount of control on the board. Distribution preferences is another one. What a distribution preference is when you negotiate and you say, I want to be paid a certain amount first before other partners. Like the 1E partners want to get paid a little bit of a bump. Sometimes they get a preferred return, which is like, okay, I put in $1 million, I want my $1 million back plus an agreed upon preferred return of say 8%. So they get $1 million plus that 8% bump before anybody else gets a dollar. Then we split it whatever way we want. Because I told you, special allocations in a prior video allows you to do that as long as, if you recall, the document matches the economic reality. Then it has what's called substantial economic effect. And you can do that. So you can make investors happy, you can get capital coming in a lot of ways, with LLCs being the most creative and flexible way. Lastly, I would say convertible debt alternative. If my clients are the investors, I'm typically always going to want to negotiate for them to receive convertible debt. Why? The reason why is because I want to limit their risk while maximizing their upside. You're limiting the risk by being debt at first. Remember, debt gets paid back before equity. So you're higher up than all the shareholders if things go bad. It's not a security interest. I mean, it could be, but it's not typically. But it's higher up on the cap table. And then, conversely, if the company starts to perform, you can convert to an equity position and capture that upside. So I would recommend that. And I guess it might be worth saying that I would always steer clients away from these fancy, shiny objects called SAFEs. S-A-F-E. That's Sierra Alpha Foxtrot Echo. They stand for Simple Agreements for Future Equity. Those are disasters. Those are a gray area between equity and capital where you don't really have a lot of rights other than the contract. And I've seen it firsthand, both personally and professionally, where that does not work out so well for investors. So I would strongly encourage you to avoid those for your clients. Stick to equity or stick to the convertible equity, the convertible debt rather. It's better for them and less headache. So moving on now to profits interest. I think I mentioned it earlier about how you're giving equity upside without the tax on receipt. A little bit more on that, just to add something. They're non-capital in nature. What that means. Again, I have a video on this, so don't worry. They're non-capital, meaning that if the company went out of business or liquidated the next day, the person who gets the profit interest would not get any money. But if the company appreciates in value, they would participate in that appreciation. So if it is an exit, there's $1 million valuation on receipt and it's an exit of $101 million, they'll participate in $100 million in appreciation. Often they're non-voting interest, but they could be voting. They get K1s as a partner with their proportionate share of profits and losses, just the same as the other partners do. I think these are great for attracting key personnel. And it's really good to help people to be able to have that profit upside without the tax on receipt. And also I should say there's usually not a requirement to participate in capital calls either. So that's profits interest. That will conclude our part about raising capital and some deal terms. In the next video, we're going to start talking about trusts and how trusts and LLCs coexist. Thank you for stopping by, and stay tuned for more. Hi, welcome back to Estate Planning Using LLCs for Professionals. I am Barry Haimo. I am your host. Thank you for stopping by today. Today we're jumping into Trusts 101. And that relates to LLCs. I'm sure you're wondering why. Because LLCs are inevitably going to be owned by trusts in sophisticated estate planning. So what are trusts? Well, I would define a trust as a legal entity that is composed of three main parts: a trustee who manages assets for the beneficiaries. That is as simple as you're going to get. Okay? There's a lot of parties to a trust beyond those I just mentioned. You have the grantor or the creator, sometimes called a settler. You have a trustee, successor trustees. You have beneficiaries and successor, remainder, and contingent beneficiaries. You have trust protectors, which are one of my favorite things. And of course, successor trust protectors. You have directed trustees and designated representatives, at least in Florida. There's a lot of parties that could be relevant in a trust. You have to always look at the trust agreement to see what it says. So Trust 101. They can last up to 1,000 years in Florida, and other states are different times. There used to be something called the rule against perpetuity, which was a law school nightmare and bar exam nightmare, but the states have mostly codified that. In Florida, it's 1,000 years. Trust can own property, like a business, like a company, like a human. They can transact, they can buy, they can sell, they can have bank accounts, they can own stuff. The trustee manages the assets, they hire professionals, they make distributions, typically of income or principal, or both income and principal, to the beneficiaries for whatever, on what standard the agreement dictates, whether it's health, education, maintenance, and support, or HEMS, or it is discretionary, partial discretionary, best interests. There's a lot of ways to do this. Trustees are typically fiduciaries, which means they have a elevated standard of care to make sure that they are administering the trust in accordance with the terms of the agreement, and always looking out for the beneficiaries, who are really the equitable owners of the assets. Okay, so trusts can be divided into a lot of different kinds. There's grantor trusts and non-grantor trusts. Grantor trusts, and I have some visual aids here that I can share with you. Grantor trusts are trusts that are typically in the grantor's estate for income tax and estate tax planning. What that translates to in English is that if there's income in that trust, it's going to go on your 1040. Whether it's irrevocable or revocable, it can be structured to go on your 1040, which is advantageous for tax purposes because irrevocable trusts that are non-grantor trusts get slaughtered for tax purposes without careful planning and without professional help. So grantor trusts are just another way of owning assets that are not in your name as a human. They don't have incapacity, they don't die, they last a long time, and they continue cruising along, as I say. The car keeps driving with different management, different drivers when those life events do happen. Non-grantor trusts are separate legal entities. They file a 1041. Every year there's usually accountings and tax returns and trustees. They're great vehicles, not for everybody, but they're great vehicles. I have a whole lot of stuff on this on my YouTube channel in the Bite-Sized Bits of Knowledge series, so I will not get into that now. I just wanted to let you know, though, that there are two kinds: revocable, irrevocable, grantor, non-grantor, and sometimes you have your irrevocable grantor trust, which is important for our purposes of talking about this because you sometimes might want to have a trust own the LLC, and the LLC can pass through to that trust, and it needs to be thought through as to how that LLC is taxed and how that trust is taxed. So, be mindful of that. There are two things I would mention in terms of, I know I have it later. Let me see if I have it later. I do. I have it later, so I'll spare you at the moment on the issues that trusts can experience if there are LLCs that are taxed a certain way. There's ways around it. But I'm going to make you wait. I'm going to leave you in suspense. So that's your Trust 101. In this context, go to our YouTube channel, Haimo Law TV, Bite-Sized Bits of Knowledge series. There's a lot of really good stuff in there to learn more about trusts and how they work and getting under the hood mechanically. All right, thank you for stopping by and stay tuned for more. Hi, welcome back to Estate Planning Using LLCs for Professionals. My name is Barry Haimo and I am your host. Today we're getting into succession planning. To start off with, I just recently posted an article in LexisNexis's Practical Guidance entitled The Intersection of Business Succession Planning and Estate Planning. Although it is behind a paywall, if you're a client or customer of LexisNexis, I would encourage you to check it out. It's about 20 pages. It could be its own CLE. You know, it's a lot of content there. And so we're going to cover it at a high level today. I want to give you an important statistic to think about to get started. Number one, did you know that $84 trillion is going to pass from the baby boomer generation by 2045? That is an insane amount of money and value that is hopefully going to pass. But as we're going to learn soon, it's probably not going to all end up in the next generation. It's going to dissipate into the thin air. And it's unfortunate that that is the case. So, what are the goals of succession planning? Obviously, avoiding probate and guardianship. You know, probate's the process of dealing with your affairs when you pass, and guardianship is the cord that deals with incapacity and getting the right fiduciaries in the form of a guardian appointed, or if you have estate plan documents, having your documents upheld. Protecting and preserving wealth, minimize taxes. Everybody wants to minimize taxes. Maximize the likelihood of a successful transition. Maximize the amount of value that is shifted to the next generation, the beneficiaries and successors, which I alluded to earlier. It's very unlikely that full amount is going to pass, I'm telling you. In terms of applicability, we're talking about succession relates to death, disability, I would say retirement is a very important one to think about. Generally, the business is the largest asset in someone's estate, so it needs to have the most attention and needs to be taken seriously. Sometimes exit isn't on the table, so succession is the only option. For example, well, I think I'll talk about it later, but just in case, you know, sometimes we have clients where they could sell it for a certain amount, but that money, if invested, would not produce the same income. And if you're dealing with retirement and your income needs for retirement, you have to make sure that you're addressing that properly. Otherwise, you could sell, have an exit, and then not have enough money to survive, or at least have a meaningful life in retirement. Some people, on the opposite, they can exit for a lot of money. They don't want to. They don't have succession plans. There's nobody that can take over the business, and they refuse to sell, when in reality selling is probably the simplest way to maximize value to transfer to your heirs. So what are some of the problems? Lack of planning is one. People don't want to talk about death and disability. I don't care, we'll deal with it later. I'll be gone, it doesn't matter to me. That's a terrible attitude for my business. I will not have it. It's really putting your family at a disadvantage. I would say to people, somewhat in jest, if you don't like your family, don't do any planning. If you don't like them, put them through the probate process. It's the ultimate scavenger hunt. It's really the ultimate FU if you don't like them. If you do like them, you want to avoid that process and make sure you've planned. You want to have the right documentation, the right insurance, the right advisors. Timing, I just alluded to earlier, is important. Sometimes people don't want to sell when they should. Sometimes it takes 3 to 5 years to get it into a packaged product to sell. Exit planning is its own specialty nowadays. There's something called a CEPA, Certified Exit Planner. You know, lawyers and accountants are helpful there, and advisors as well. Timing is everything. Having the attention, focus. It's all these ingredients make up the formula for a successful succession plan. Another problem is, like, as I said, sometimes the math doesn't math. You know, you gotta just look at it and be objective in your job. One of the main things I said in my blog on Lexis was, like, sometimes you have to be the bearer of bad news to your clients and tell them what they don't want to hear. And that's our job as advisors. You know, be objective and give advice. Not always telling our clients what we want to hear. The biggest boulders to move when it comes to succession planning is succession of management and key personnel. Getting the blocking and tackling right. It's not always just about the legal. It really isn't. Systems, processes. This is what my blog post is about. Systems, processes, understanding the business, who's going to be the right person, how to structure it, how to get compensation, incentives, rewards, etc. And of course, the last on my list of boulders is tax strategy. How to maximize the transaction so it's the most tax efficient way to do it. When it comes to succession of management and key personnel, we're talking about compensation. You got to think about it. To get the right people in the right places, the right thing, the right time. Are you promoting from internal people? Promoting from within? Are you hiring outside people? Who's on the board? Who's not on the board? What are the SOPs? The standard operating procedures and R&R. Roles and responsibilities of these key people. It needs to be buttoned up tight. Compensation needs to be figured out. Stock options, warrants, profits, interest. We'll talk about that later. Vesting schedules. Are there milestones? Specific milestones that need to be hit. You got to really know your business to be able to structure this the right way. And you got to make sure that you're in alignment with the people and how they're motivated. Not everybody's motivated by stock. They just want the money, and a lot of it. There's a lot of options to incentivize people. To stick around is very subjective. You got to really get to know the people and what they're asking for, and it's a conversation. Don't assume. There's insurance that you can buy, invest in, profits, interest, bonuses, upward mobility. There's a lot of stuff you can do. It's pretty cool. I think the key is communication, though. When it comes to the legal components that make up this plan, that are the infrastructure of this plan, you have your operating agreement, because we're talking about LLCs. Those need to have buy-sells. They need to have key covenants where available and applicable, like non-compete, non-solicitation, confidentiality, of course. You want to make sure you're protecting your trade secrets. Employment agreements with those same covenants, those same things. I have a whole video on employment agreements in my YouTube video and bite-sized bits of knowledge. So I'm not going to go into the details of what goes into an employment agreement. And then, of course, profits, interest, award agreements, which are similar to employment agreements, but they're more geared towards what are the components of profits, interest, and how to maintain the tax benefits of them. So tax strategies of succession planning. There's a couple I want to talk about today. As I said, this is a whole CLE in itself, but one of the things is involving trust. That's why I wanted to introduce trust before. One specific type of trust that we talked about was a intentionally defective grantor trust, or an IDGIT. And these are trusts, as I mentioned, are irrevocable in nature, and they are taxed for income tax purposes to the grantor, but for estate tax purposes, they're out of the grantor's estate. So it's kind of a Venn diagram of where they are in terms of tax. What's interesting about them is how they work. So one strategy that you can use for succession is to seed fund a IDGIT with some cash by way of a gift or loan, and then that trust will buy your assets. And they can buy your assets, they can buy your LLC, they can buy a partial interest in both in exchange for financing. So a note over a certain amount of time plus interest at what's called the applicable federal rate. And what that does is that your estate transferred this business from here to here. This is your estate and this is outside your estate. Your estate now has a note, which is frozen, and your trust, which is outside your estate, has the business and all the appreciation in the future. The note decreases with every payment, and you're going to spend that money probably. So it's helping you reduce your estate, and then you have your IDGIT, which has the business. And so this is one way to get your business out of your estate for tax planning and shift management and control to someone else, potentially, to ensure that that business continues without estate tax in the future, and for the benefit of those people who you designate. Trust protectors are really helpful. That's why we talked about it earlier. in terms of making sure that your wishes are carried out and creating enough flexibility and checks and balances. Another option to move LLCs around is a grantor retained annuity trust. A grantor retained annuity trust, or a GRAT. This is also an irrevocable grantor trust, meaning the income is taxed to the grantor. Like an IDGIT, you seed fund it with money by way of a gift or assets by way of a gift. In this particular case, we're talking about an LLC by way of a gift. And that LLC will have income that has to be paid out to the grantor for a specified amount of time. At the end of that period of time, whatever money is left is gift tax free to the beneficiaries in that trust, and it's out of your estate. So these types of trusts are tied to the interest rates. So when interest rates are high, they're less advantageous because there's less margin of gain. So unless your business is really performing well, if interest rates are at 8%, you really got to do pretty well in your business to exceed the cost of that annuity. When interest rates were low during COVID, and interest rates were in the 2s or less, obviously putting money in there at low rates in the bank even probably covered your spread, and you can leave a nice meaningful gift at the end of that term. Another one is a spousal lifetime access trust, or a SLAT. Not a slut, but a SLAT. Spousal lifetime access trust. This is where you have spouses that fund a irrevocable grantor trust for the benefit of the other spouse. Usually you kind of do it like this reciprocally, but they must not be the same. They must be materially different. That's a whole issue that you must navigate very carefully. The IRS will disregard them if they are the same. If they are successfully separate, you've effectively gifted assets to the other spouse outside the estate forever, which is helpful in terms of making sure that business doesn't get subject to estate tax later, and the right management is set through the trust level. In terms of succession, and some other tax strategies are 1202. IRC 1202, Internal Revenue Code Section 1202. It's really important you understand 1202. What stands for Qualified Small Business Stock, QSBS, Qualified Small Business Stock. 1202 is a really interesting code section. It essentially allows you to exclude a massive amount of income tax on the sale of your business. If your business qualifies, your business to qualify has a lot of requirements. It has to be a C Corp that you've held for over 5 years. As a certain type of business, they exclude a lot of them, like they shouldn't, but they do. It has to be original issue, and it has to have a certain gross assets less than 50 million. And you have to sell your company for equity, not assets. And this is an interesting point, a lot of companies sell their assets, not their equity. So also in Florida, another downside is that you have a corporate income tax of 5.5% on your C Corps. So you got to be pretty sure that you're going to exit as an equity sale. The areas that come to mind to me that are equity sales are like in medicine, where you have an EIN tied to an insurance vendor, insurance company. It's really hard to deal with those insurance companies. So oftentimes, in my experience, medical companies of any kind typically sell the equity. Similarly, if you're a vendor at like a major organization like Walmart, it's not easy to get in there. To have to get in there again is hard. So for that reason, it's easier sometimes just to buy the EIN and the vendor status. So you sell your equity. So what does it matter if you qualify? Well, you can exclude a lot of money. It's changed over the years from 50 to 75% to 100% of the tax. So now it's 100% of the tax, and as of last year in the big beautiful bill, that amount is the greater of 10 times your adjusted basis, or 15 million per taxpayer. This could add up to a lot of money. I mean, think about it, 10 times your adjusted basis. If you put money in, if you put 15 million or more, your greater is going to be on your basis. If you put less than 15 million, then the 15 million is your max. But there's a lot of creative structuring you could do to multiply the benefits here when it comes to trusts. So it's something you need to be mindful of, but also be mindful that there's difficulty, in using it. If you don't qualify, or you think you qualify but you're mistaken, or if you don't sell the equity, or just generally dealing with the tax along the way. Moving forward, problems that are often overlooked. Trust as the owner of an LLC. I think we talk about that in a later video. Dealing with triggers, making sure that they're not tied to the entity, but the triggers are tied to the trustee. So that way, if your trustee is the one who's disabled, then it kicks in, because you don't want to be having your partners be partners with spouses and creditors and other possibly non-qualified people or disinterested people. So you need to make sure you're connecting the dots on the triggers of the buy-sells with the trustee, and being careful, because sometimes you might be okay with certain parties and not others. Trust protectors are helpful because of the flexibility and oversight in these contexts, but these are things that need to be thought through, I must say. Again, there's a lot to go over in succession that we haven't really got to, but that's a good start for today. The next video is going to be talking about estate tax planning. I'm excited, so stay tuned for more, and thanks for stopping by. All right, welcome back to Using LLCs and Estate Planning for Professionals. My name is Barry Haimo, and I am your host. Today we're talking about estate tax planning. We're going to get into how LLCs are relevant to estate tax planning. So, to begin, tax strategies, some existing ideas that we've already talked about in the prior video. We're using IDGITs to purchase LLC interests. If you recall, that was when you create and fund an irrevocable defective grantor trust. You fund it with a gift. That trust then uses the cash plus possibly leverage to acquire the LLC interest from your estate, freezing it in the way of a note that gets reduced in value every payment. The appreciation is shifted out of the estate for estate tax purposes, while you retain income tax obligations on it, which is better taxation than an irrevocable trust. Another was a grantor retained annuity trust, where there's an annuity that goes out, and whatever's left at the end of the term is gifted estate tax free. Last was a SLAT, spousal lifetime access trust, where you gift reciprocally, but not actually the same trust, with very material differences from one spouse to another. Gifts of maybe an LLC interest that can shift that appreciation outside of the estates for estate tax purposes. New ideas. Basis adjustment, 754 elections, and discounting. Let's get into it. So, basis adjustment. I have a video on basis in our YouTube series called Bite-Sized Bits of Knowledge on estate planning. It's a really helpful video, so I will assume that you understand what basis is at this time. For a 30-second overview of basis, it's what you pay for it plus all your improvements. It's a moving target, it's a variable. Your basis is one thing, your adjusted basis is another. The difference between the purchase price and your adjusted basis is how you compute your tax, gain or loss. There's something called a step-up in basis versus a carryover basis. And this is a very important distinction, and it's income tax relevant, not so much estate tax relevant. So the step-up in basis is when you pass away, your basis goes up to the value at the time of death. So if you bought something 100 years ago for $10 and it's worth $10 million, your basis goes from $10 to $10 million upon death. If your beneficiaries sell that property upon death for $10 million, then their difference between $10 million and $10 million is zero, which means that there's little to no estate tax on that sale. It's a very big deal, because it's quite a difference if they sold it during life or they gifted it to you during life and then you sold it later. You would get it with that tax of 10 million minus 10. It's a big difference. People make mistakes about this all the time. Carryover basis is when you gift it to someone, they inherit your basis, which of course maintains that margin of tax. So step-up basis is really important. Gifting on death, in one way or another, there's many ways that can happen, is important. In a business setting, in an LLC, there's two kinds of bases though. There's the basis that's the outside basis, and there's the basis that's the inside basis. The outside basis is your interest in the company, your inside basis is your company's interest in the property itself. So to reconcile that distinction between those two bases, you can do an IRC Section 754 election, which unifies those two things. What happens is that outside basis steps up, but not inside basis without it, so you can do this election to reconcile what would be two very divergent numbers. It saves tax, increases depreciation, it defers capital gains, and minimizes tax with trusts, particularly trusts, as owner. But it's irrevocable. It's difficult to revoke, so you gotta be careful with your 754 election. All right, new investment opportunities. When it comes to estate tax planning, new investment opportunities, you can create and fund or seed fund a new LLC to own those investment opportunities. If you have other family members own it, maybe you can lend to it. So if you lend to it, you can lend to it at what's called the applicable federal rate, AFR, applicable federal rate, which is the lowest rate the IRS will accept or honor between related parties. So you're allowed to do business with related parties and give a better deal, but you have to at least give the right amount of interest. So if you have a new opportunity that you think is worth $100 million and you want to not have that $100 million in your estate, you can shift it out of your estate by funding with a loan a new company and having that company be owned by your family or a trust, and then that company borrows from you, invests in the property, the $100 million goes there, and you're just left with this loan. So it's a really, really smart way to shift that value anywhere you want, but not you. Discounting. What is discounting? So let me ask you a question. Two questions, really. Would you pay fair market value for a minority stake in a company? Would you pay your pro rata share of the fair market value of a minority interest? That means a non-controlling 49% or less. Obviously, you can have, at this point in the flexibility discussion of why I love LLCs, you can have a company where you own a majority interest but you don't have control. But for purposes of my question, would you buy a minority interest for fair market value? The answer is no. Do you know why? The answer is no. The reason is because you're not in control of the company. You have no idea. You have no ability to control vision, distributions, hiring, firing. You're just along for the ride. So you're not going to pay for that risk of being along for the ride. You can't control it. Let me ask you another question. Would you pay the fair market value for a pro rata share of a company that is unmarketable, meaning it cannot be sold? Nobody will buy it. Either nobody can buy it or nobody will buy it or wants to buy it. Would you pay fair market value for that? Would you pay for that share? The answer is no. Why would you pay for something, the fair market value of it, if you can't sell it? What you're probably thinking about is, well, then why is the fair market value the fair market value? If the answer is no, the fair market value should be lower. And that's kind of precisely the thinking here. There is a discount that is permissible by the Internal Revenue Code that says that you can get a meaningful discount on the value of a business that is subject to either one or both of those things. Between a 0 and 33% is a reasonable range of discount. So if you have a $100 million business and you make it go down to 75 million, but the business hasn't changed fundamentally, you've shifted theoretically 25 million in value by taking advantage of some strategies and what's called discounting. Now, there's a lot of rules on how to do this the right way, and there's a lot of risk to do it the right way, but it can be a really effective tool. There are cases the IRS is kind of revealing its analysis. The IRS, obviously people played games with this, and then the IRS gets involved, they litigate it, and there's new cases that give precedent on how what is susceptible to risk of getting this overturned. So you got to be careful. You really got to know what you're doing here. But discounting and in the context of estate tax planning is a really good tool. Those cases that I mentioned are Strangey, Powell, and Bongard, all versus the commissioner. There's 3 separate cases, each versus the commissioner. I would say the issues you got to be mindful of are legitimate and substantial non-tax purposes. Mindful of running afoul of controlling the beneficial enjoyment under 2036, which they now view very broadly and aggressively. Lastly, substantial economic effect. It's something I've referenced multiple times in our videos. It's a common theme. The economics in the agreement must match the reality. That is something that I think I'm being a dead horse at this point. So estate tax planning with LLCs is a really cool concept. There's a lot more to it. For today, we're covering a bunch of trusts. I think we covered three to five things that you can do. I hope that you find it valuable for your practice to add value to your clients. In the next video, we're going to talk about income tax issues with trusts and LLCs. And we're going to wrap it up with this particular video series. Again, Barry Haimo, thank you for stopping by, and stay tuned for more. Hi, welcome back to Estate Planning Using LLCs for Professionals. My name is Barry Haimo, and I am your host. Today, we are talking about income taxes and issues with trusts and LLCs. So oftentimes I hear from clients like, oh, I don't want to have a trust on my LLC because that's bad. And I ask them questions and they tell me all the things that they saw online that say it's bad, and that's usually wrong. So I addressed in an earlier video about operating agreements and making sure that particularly triggers are tied to the trustees or the partner that you really care about, and making sure that when the trust succeeds to the next generation, spouses and kids, like we're addressing what needs to be addressed and it's not overlooked. But when it comes to taxes, there's some interesting issues. So while you're alive, a grantor trust can own an LLC, there's no issue. It's black and white. But when you pass away, your LLCs that are taxed as an S corporation, as I mentioned earlier, cannot be owned by non-US citizen humans. So you have a trust, which is a non-person, not a natural person, that is its own taxable entity, is an owner of an LLC taxed as an S. It's a problem. But there are two solutions. Two. Number one, you'll find it in a lot of good trusts, a QIST or a qualified subchapter S trust under IRC 1361. To retain that S election status of the company and not to destroy it and cause a lot of problems, you have to comply with a couple of rules. The trust needs to be structured properly. Some of those rules are mandatory income distributions, single principal and income beneficiaries. The beneficiary must also be a U.S. citizen or resident, and there's also an election. You must timely make that election. It's around 2 years after death. So you have a grace period in which you can decide which one to do. The other option is an electing small business trust, or a ESBT, also under the same code section. To retain S status under that section, it requires also compliance with some rules. It needs to be structured properly. It is different in the sense that it can have multiple beneficiaries, unlike the Quist. It's easier to comply, but it has less favorable taxes. It also has an election that must be timely filed. So you need to make sure that you're aware of these. The elections are made properly, and that way it won't destroy an otherwise, profitable S Corp LLC. We did also talk about the 754 election, and that was an income tax issue of having inside-outside basis. So I'll leave that to the video in which we talked about it. And we didn't really get into pass-through taxation, but I can do a quick 30 seconds on that. Basically, C Corps, they have their own 1120 that they file, and they pay taxes. Distributions get paid to investors or shareholders, and those shareholders pay tax. And that's why it's double taxation, because you have the corporation as a whole, as an entity, is paying tax, and then that post-tax money is distributed and gets taxed again. For smaller businesses, there's the S Corp and there's the partnership that are called pass-through entities. And what happens with these is that they file informational returns by way of an 1120S for an S Corp or a 1065 for a partnership. It just says, here's the partners, here's their percentage of, or their pro rata share of profits and losses, unless otherwise contractually agreed upon, in the spirit of that substantial economic effect I've alluded to many times in our videos in this series. And those 1065 or 1120Ss have a K1 for each partner, and those K1s, they get attached to those respective partners' 1040s, and the tax that derives from that asset is reported on the 1040 and paid at the personal rates, not the corporate rates and not the trust rates while you're alive. If it's an irrevocable trust, it's a whole other story. They have to pay adverse taxes, much higher amounts and thresholds, much higher amounts at much lower thresholds, and there's ways around that with proper professional advice and planning. So an LLC does not get punished in a pass-through as long as you can properly plan for and distribute the income. As I mentioned in a prior video, partnership tax was one of the most complicated of my courses ever taken in law school, computer science, and tax. Tax is a complicated area. You want to have the right professionals advising you in the trust context, as well as the LLC, and then of course the tax context. So hope you found this helpful. Subsequent videos are going to be interesting on various topics, and I tie it all up at the end. So thank you for stopping by, and stay tuned for more. Hey, welcome back to Estate Planning Using LLCs for Professionals. My name is Barry Haimo, and I am your host. This video puts it all together. We've covered so many different things in this series of videos. I hope you found them helpful to your clients to give more value and provide more counsel in a variety of different circumstances pertaining to estate planning and specifically LLCs. So if I were to give you the wrap up here, LLCs are awesome. I love them. They're fun and exciting, and I nerd out by reading the statute. I know it's weird. They're the ultimate hybrid. They're flexible in so many ways. That's why I call them the ultimate hybrid. They can be, in terms of their structure, they can be managed by management. They can be managed by the managers, or they can be managed by members. They can mirror corporations. They can mirror partnerships. There's 4 different ways they can be taxed, which we talked about: disregarded, partnerships, C and S. There's an unlimited number of shareholders and type of shareholders, unlike S Corps and C Corps. You have a lot more creativity that you can enjoy in deal making with raising capital than you can with C Corps and S Corps. You have a greater ability to modify terms that are in the statute, which are your otherwise default rules. We talked about the statute being over 120 pages in Florida. So when your lawyer gives you a really good operating agreement that's 60 pages, say thank you. They're excellent asset protection vehicles. We talked about inside basis, outside basis. I'm sorry, Jesus. We talked about, scratch that. They're excellent asset protection vehicles if structured properly. We talked about inside creditors and outside creditors. Creditors of the business versus creditors of the owners. That matters. Different states have different rules. There's different strategies that we can employ to protect your assets and make them off the table from creditors legitimately. And lastly, I would say they're useful tools in succession, estate tax planning, and income tax planning. So using LLCs in conjunction with trusts are really good techniques. They can be done. Do not steer away from them. There's solutions to every problem. I hope that you found this video series helpful. It's been a pleasure to do it for you. If you have any questions or anything else you want me to talk about, please do feel free to reach out at info@haimo.law. That's info@HAIM as in Mike O.LAW. And I'd be happy to talk further about this. I have materials. I like this stuff, so feel free to reach out if you have any questions. I'd be delighted to talk with you. Thank you for stopping by, and stay tuned for new series in the future that we can get excited about. Thank you. Bye-bye.